In fact, I am really wondering what is left to be said on Sabarimala issue, because much deliberation is over across the globe, I would say, not across the nation alone. Because we all see that Ayyappa devotees are strewn across the world. Their concerns, their apprehensions over the judgments rendered by the Supreme Court has caused much worries over. And many persons have joined hands together for filing review petitions before the Supreme Court for reviewing the order, which has caused much agony to the devotees of Ayyappa. And before going to the judgment, I think that the focus must be not on the judgment or its pros and cons, flaws, defects, demerits, etc. But the focus must be on how to resolve the impasse as of now. Because the review petition is already pending before the Supreme Court, which has been heard and which the judgment has been reserved. But at the same time, now it has come out by way of a private bill going to be piloted by one MP from Kerala, N.K. Premachandran. That has now in fact engaged the attention of the entire nation. But the feasibility of a bill being passed and its consequent challenge or expected challenge before the court again, all these matters are in fact matters of concern for the Ayyappa devotees. Before going much into the various niceties of the private bill, which is going to be introduced by the member, let us have a look at what in fact happened in Sabarimala and the age-old custom or the rites which are prevailing there and which are followed meticulously and scrupulously by the devotees who are visiting the holy shrine. We all know that these women of a particular age, that is women from menarche to menopause, are not allowed to enter the holy shrine of Lord Ayyappa. That is based on a custom, and the custom and the rites are in fact emanating from the astrological revelations which have come out by way of a Deva Prashnam that was undertaken in the Sabarimala temple. And there was, people would say that before 1993, rarely women devotees visited there. And the Kerala High Court, we all know that the Kerala High Court is having jurisdiction, that is, though it is called one account jurisdiction, it has assumed the jurisdiction regarding the administration of the temple itself now. The audit jurisdiction which the Kerala High Court has been conferred by the Travancore Cochin Hindu Religious Institution Act has now been taken over by the Kerala High Court as a jurisdiction vested with it for overseeing the entire administration. This has led to a historic judgment on this Sabarimala women entry issue in 1993. The then Devasam Commissioner, one Chandrika, happened to be with her family members who all are falling within this age group of 10 to 50 for attending a ceremony of the first feeding of her granddaughter. And this matter came out through a letter which was sent by a devotee to the Kerala High Court. The Kerala High Court had taken suo motu proceedings in respect of this issue. And unusually, we could see that this Kerala High Court, though had assumed the jurisdiction under Article 226 of the Constitution of India, as this being a matter which is resulting in violation of the religious practices ensured under Article 26 of the Constitution of the devotees, the proceedings commenced like a civil suit, where evidence was taken unusually in a proceeding under Article 226 of the Constitution. Witnesses including the Tandri and persons who were having intimate and intricate knowledge about the custom which was prevailing there, including the family members of the royal family members of Pandalam, were summoned and their evidence was taken. And the Tandri was also summoned, the astrologer was summoned, based on a comprehensive adjudication, like an adjudication regarding the existence of a custom or right. The Kerala High Court came to the conclusion that there was astrological revelation which throws light on the wishes of the deity Lord Ayyappa. According to the astrological revelations, Lord Ayyappa is having the manifestation of an eternal celibate in Sabarimala, and the deity, since it is in that manifestation, does not like the presence of women of childbearing age. And the Kerala High Court, in the historic decision that is titled as Mahendran versus Travancore Devasam Board, declared that women of childbearing age, that is particularly and specifically categorized as women falling within the age group of 10 to 50, are not allowed to enter a holy shrine at Sabarimala. So this was the decision that was taken by the Kerala High Court in a comprehensive and I would say that somewhat a meticulous litigation regarding the existence of a custom. And this remains unchallenged. This is a judgment rendered by the Supreme Court under Article 226 of the Constitution of India by taking evidence regarding the existence of custom. This has not been taken by way of an appeal before the Supreme Court. And this decision is rendered under Article 226 of the Constitution, which is in fact coordinated and concurrent with the jurisdiction of the Supreme Court under Article 32 of the Constitution. So in a way, the present judgment rendered by the Supreme Court, the Apex Court, is one under Article 32 of the Constitution of India. We all know that the power of the High Court is somewhat wider than the power of the Supreme Court under Article 32 of the Constitution. As far as Article 32 is concerned, the Supreme Court can adjudicate upon the violation of fundamental rights guaranteed under Part 3 of the Constitution, whereas the High Courts under Article 226 can adjudicate issues regarding violation of fundamental rights as also violation of other ordinary rights. So, one flaw which I would point out, probably this might have been argued before the Supreme Court, but one flaw is that a judgment that is rendered by a High Court under Article 226 has not been taken in the proper and established way by way of an appeal before the Supreme Court. The Supreme Court assumed jurisdiction under Article 32 and decided the issue. We can say that it has overruled the decision of the Kerala High Court, but not in the established way of filing an appeal against the Kerala High Court decision under Article 136 of the Constitution of India. So this may cause some chaotic situations in future regarding the jurisdictions of the Kerala High Court and also not the Kerala High Court alone but the High Courts and the Supreme Court under Article 32. This has set a bad precedent in as much as it has given a go-by to the ordinary way of appeal which is provided under Article 136 of the Constitution. This is one aspect which I could see that this is a way in which the Supreme Court has overstepped the constitutional limitations, or I could say that it has transgressed the constitutional limitations regarding the jurisdictions and the assignment of jurisdictions. As far as the issue which was deliberated before the Supreme Court in Sabarimala is concerned, the pivotal issue, I would say that on the reading of the judgment we can see that the interpretation of Article 25 of the Constitution, Article 26 of the Constitution, Article 25 of the Constitution is dealing with the right of a citizen or any person. Right of any person. I would say right of any person, because I have once again gone through Article 25, which clearly says not a citizen, but this right is conferred on any person to propagate his religion, practice his religion, and protect his freedom of conscience. But the state can make laws with regard to the entry of persons or entry of devotees in places of public worship of Hindus. This is provided under Article 25 of the Constitution of India. Under Article 26, a very important and cardinal right is given as far as religious practices are concerned. The article provides that, subject to public order, morality, and health, every denomination or class of persons have got right to manage their religious affairs. In the matter of religious affairs, every denomination and every section, I would once again emphasize that every section of the devotee has got a fundamental right guaranteed under Article 26 to manage religious affairs, which by various interpretations of the Supreme Court has been brought within the phraseology of essential religious practices, which in short I could see in some literature on this, ERP, essential religious practices. These essential religious practices was in fact a subject matter of adjudication before the Supreme Court in Sabarimala issue. When we come across these essential religious practices protected under Article 26 of the Constitution, the first case which come to my knowledge come to my memory is the Shirur Mud case. The Shirur Mud case that was decided in 1954, which in fact had gone into the issue of essential religious practices which are guaranteed under Article 26 of the Constitution. The court had undertaken a strenuous exercise of defining these essential religious practices. But when we go through the judgment, we could see that they also were helpless in bringing it within a straitjacket formula, and said in very clear terms that this is something that is left to the doctrine of the religion. The doctrine of the religion that determines what are the essential practices and customs regarding worship of deity, temple entry, etc., etc. And also, the decision also specifically says about certain places in the temple precincts itself where people are not allowed to enter and offer worship on their own without the aid of a priest. And this Shirur Mud case was ruling the roost for some time. And I think that that has correctly decided the issue regarding essential religious practices. India is a country where numerous religions, numerous sects, etc. are prevailing. They have their own religious practices being followed, rituals being followed, ritual protocol is being maintained in temples or mosques or places of worship. This we cannot bring within a straitjacket formula. But when it offends public order or morality or health, in such cases, court's intervention is permissible. Then yet another case also, which also come to my memory is one regarding the Badrinath temple case. Badrinath temple case is a peculiar case because its facts unfold a peculiar situation. We all know that this Badrinath is on the northern end of India in Uttarakhand. And it is also believed that Shankaracharya had done the consecration there at Badrinath temple. And it was also ordained by Shankaracharya that the priest who is supposed to perform the rites and rituals therein must be a priest from northern Malabar. And the northern Malabar Malayali Brahmin family is given the priesthood and was ordained by Shankaracharya. What happened therein was a sect that is Pandas, which they are residing at Devaprayag, they raised some grievances regarding their entry into the temple. They were persons who were usually escorting the pilgrims to this place. They asserted their right of offering worship directly on the idol, like doing ablution, giving ambrosia, etc., etc. But that was objected to by the priest class. A suit was filed under Order 1 Rule 8 of the CPC for declaration of the right of Pandas to enter into the temple and offer worship, which was against what was ordained by Shankaracharya. And the matter ultimately came before the Supreme Court, and the Supreme Court said that an assertion of a right which is contrary to a religious practice that is followed is not one guaranteed under Article 26 of the Constitution of India, and the Pandas cannot exercise or exert their rights of entry into the temple. These two decisions, that is one, that is Shirur Mutt case and the Badrinath temple case, were rightly decided with good legal acumen without the vagaries or delusions of neoliberalism, which now we see in interpretation of constitutions. What is actually existing, what was intended by the framers of the constitution for preservation of religious rights was fiercely protected by the Supreme Court by its various interpretations in these decisions, and which has been there for time, I would say more than 60 years. This proposition was the one which was followed as an adage so far as the constitution is the interpretation of constitution is concerned. But the Sabarimala decision, the judgment rendered by the Supreme Court, is a kind of a neoliberal adventurism to satisfy or to satiate the needs of the present day generations who are not in fact into the field of religious practices and rites. Whatever it be, it has caused much pain and agony to the devotee class as a whole. I would say with all candor that the majority judgment was not appealing or convincing. When we go by the traditional interpretations of the various constitutional provisions relating to religious practices. But the minority judgment that was rendered by Indu Malhotra is somewhat on the lines of established interpretations regarding the religious rights guaranteed under Article 26 of the Constitution. The majority judgment would say that the denial of entry of women of childbearing age, exactly women falling within the age group of 10 to 50 years, is violative of Article 14 of the Constitution, Article 15 of the Constitution, Article 25 of the Constitution, which is dealing with the fundamental rights for practice of religion. The Supreme Court, while dealing with Article 25, would say that the women of this age, that is menarche to menopause, are a class by themselves and they have every right to enter the holy shrine, and the denial of which would be violative of Article 25 of the Constitution. While interpreting Article 25 of the Constitution, we feel some sort of a missing between Article 25 and 26. There is no synchronization regarding Article 25 and 26. It is not harmoniously being construed. Individual rights, we all see that the Constitution contains fundamental rights under the Part 3 of the Constitution. In Part 3 of the Constitution, as far as rights guaranteed under Article 14, 15, 16, etc. are concerned, we see that these are all personal rights or individual rights. Part 3 of the Constitution, in the first couple of articles, are dealing with individual rights. But when it comes down to Article 25, 26, 27, 28 and 29, we could see that this is what is protected under Part 3 of the Constitution is collective rights. The question is regarding whether collective right is subservient to individual rights. Of course, individual rights, liberty, freedom of speech, expression, etc., which an individual or citizen enjoys, is something that is precious. But this precious right will have to yield to collective rights sometimes. Individual rights, collective rights. When it comes in conflict with each other, in usual mode of harmonious interpretation, collective rights would gain some sort of dominance over individual rights. This was the way in which interpretations were going on while this exercise was being done by the Supreme Court. But we could see a deviation in the majority judgment regarding the collective rights enjoyed by the devotees of Lord Ayyappa. The collective rights enjoyed by the devotees of Lord Ayyappa under Article 26 has been made subservient to the individual rights enjoyed under Article 14 and Article 15 of the Constitution. On this score, there is a very pertinent aspect emerging when we take up the interpretation of Article 15(2) of the Constitution. When Article 15 says that no citizen shall be discriminated on the ground of religion, caste, race, sex or place of birth, Article 15 is couched in a different way. Article 15 starts that no citizen shall be subject to any liability, condition, disability or restriction with regard to entry or access to shops, places of public entertainment, restaurants, hotels, etc. on the grounds only of religion, caste, race, sex or place of birth. This Article 15(2) is assuming importance for the reason that this is the only article which deals with access or entry to certain areas. This article would say that no person shall be subject to any disability, liability or condition or restriction with regard to access to shops, public restaurants, hotels and places of public amusement. This does not say about any temple or places of worship. So the framers of the Constitution might have in their mind that religious places have a separate identity and it is considered to be somewhat a pristine or what would say that a pure place according to the notions and tenets of that particular religion. So the framers of the constitution had in their mind that various religious practices were going on, and these religious practices must be protected, so that has been classified into a class right under Article 26 of the Constitution, and the essential religious practices were protected under Article 26 of the Constitution. So when we see or when we interpret Article 15(2) in juxtaposition with Article 26 of the Constitution, we would see, and we are very much convinced, that the collective rights of freedom of religion or the essential practices of religion is somewhat on a higher pedestal than the one that is guaranteed under Article 15 and Article 14 of the Constitution. So no person can, on the ground of equality or on the ground of violation of the right guaranteed under Article 15, can stake a claim for entry into a place of public worship. But at the same time, Article 25 would say that the states concerned can make laws for throwing open the public places of worship of the places of worship of Hindus. Accordingly, the Kerala Hindu Places of Public Worship Act was passed in 1965, pursuant to which the rules were also framed for carrying out the provisions of the Act. Section 3 of the Act makes it open temple to all classes of Hindus, all sections of Hindus, but pertinently the expression sex is absent in Section 3 of the Act. Section 4 of the Act empowers the trustee of a temple to define the rituals or to categorize the rituals by way of a ritual protocol of a particular temple. Then the rules come into picture. Rule 3 specifically provides, probably by taking life from Section 4 of the Act, that women at such age during which they are prevented by custom or usage from entering temple cannot enter temple. This is the particular rule, that is Rule 3B, which was under challenge before the Supreme Court. Supreme Court said that this is ultra vires the parent provision, that is Section 3 and 4 of the Act and also Article 14 of the Constitution of India. And curiously, we could see another interpretation, and I would say that this is something, a fanciful interpretation of Article 17 of the Constitution, which prohibits untouchability. Article 17 says the practice of untouchability is forbidden, and those who practice untouchability would be made punishable under law. This Article 17 was necessitated in the Constitution not because of denial of entry of women as a class or women of a particular age into a temple or a place of worship belonging to Muslims or Christians. The historical background of incorporation of Article 17 of the Constitution was nothing but untouchability that was practiced based on caste. The lower caste people were denied entry into temple, and various other sorts of untouchability they had to face, which had to be eradicated by way of giving a constitutional sanction to this. And this was the historical background of incorporation of Article 17 of the Constitution, which has been manifested by way of a different statute, that is Protection of Civil Rights Act. The Protection of Civil Rights Act makes untouchability in any form punishable with various periods of imprisonment. But this kind of a an interpretation given to Article 17 is something that is far-fetched, and it is not in synchronization with the intention of the framers of the Constitution. That is why I have earlier said that this kind of an interpretation, based on vagaries, whims and fancies, I may be pardoned for use of these words, because it has gone to such an extent that this term of untouchability has been stretched to a level of fantasy to suit the convictions of the judges who were writing the judgments. This is not something that is intended by Article 17 of the Constitution. This is something beyond, has been brought into the Constitution by way of, the judges would say, that's an organic interpretation of Constitution. The Constitution, according to the judges, is an organic book which is susceptible to interpretations, taking into account the development of society, or when the society goes forward, the Constitution has to be adapted in line with the various developments which are taking place in the country. But this interpretation, I would once again say that it's not appealing to the ordinary intellect of a lawyer or layman also. At the same time, the interpretations or the various contentions or various conclusions which were found in the judgment of the minority, that is Indu Malhotra's judgment, is somewhat convincing. She raises a big issue first, that she says that what is the locus standi of the present petitioners who are not devotees, even according to them, to raise an issue of violation of fundamental rights guaranteed under Article 14, Article 25 and Article 15 of the Constitution. The persons who approached the court had not taken the pains for stating in their affidavit that they are devotees of Lord Ayyappa, and they were denied entry into the sanctum sanctorum of the temple or the holy hillock. The learned judge says that if this kind of petitions are allowed, various persons belonging to various other communities and they are not devotees may come again with the petitions before the courts for challenging the practices followed by various other religions. So this kind of intervention of meddlesome interlopers should be prevented. So the locus standi has to be first cleared by the petitioners, which the petitioners failed to convince the court regarding their violation of fundamental rights, as they were not devotees at all. Only the devotee has that fundamental right under Article 14, if at all they had. Then she also says that logic, the issue of bringing logic into constitutional interpretations vis-a-vis religious practices is not permissible, because rationality has no role in religious faith. Rationalization of religious faith is a futile attempt which shall not be attempted in interpretation of Constitution. If that is so done, various situations which may lead to catastrophe may emerge in future. That was what she said in her minority judgment, that is a dissenting judgment. Let us conclude this portion, that is the dissection of the judgment, by way of our discussion. And let us see what is the solution for this impasse that is created by the judgment that was delivered by the Supreme Court in Sabarimala. Let us delve into this issue, because that is now engaging focus of the entire country now. The other thing which we have already said has lost its significance because of the filing of the review petitions and various other various contentions, numerous contentions which were raised before the Supreme Court. So this is only for the purpose of giving some information regarding the judgment and its peculiar features and the contentions for appraisal by the lawyer community and also the law students. Let us get into the next issue regarding the resolution of this issue, resolution of this imbroglio. A review petition is already pending before the Supreme Court. Much has been argued on the review petition. And we can foresee the usual outcome of a review petition. The usual outcome of a review petition would be a dismissal. That is happening always. But since there was a change in the composition of the bench, there is a ray of hope, because there is already a judgment by the minority. And the present Chief Justice, Ranjan Gogoi, has not taken or has not expressed his view on this issue. He was not earlier part of the bench which decided the case. Then Justice Kanvilkar, he has not written a separate judgment on this issue, I think so. But Justice R.F. Nariman and Justice Y.B. Chandrachud, they wrote their judgment with all convincing reasons for suiting to their convictions on the interpretations of Article 25, 26 and Article 14 vis-a-vis the denial of entry of women into Sabarimala temple. But since the issue is somewhat grave and the issue and the widespread protest which erupted after the judgment and the violence unleashed in Kerala and the failure of the executive in implementing the judgment and the practical difficulties of the implementation of the judgment would naturally be taken care of by the Supreme Court, which I hope also by taking into account the developments which taken place after the rendering of the judgment. So we may expect a review of the judgment, we can expect a review of the judgment on certain issues, but the issue is not going to be concluded with the review, but the possibility is that the matter may be referred to a larger bench for an authoritative pronouncement on the interpretation of Article 26 regarding the rights of the religious rights of denominations and sections. Then another issue also may be taken note of. The Constitution, another bench of the Supreme Court, that's also a Constitution bench, is in season of very same issue in a Bora community case. In Bora community case, the Bombay Excommunication Act was challenged. Bombay Excommunication Act was earlier challenged before the Supreme Court. Bombay Excommunication Act provides or confers a special power on the priest of that community for excommunicating a member of the community for not following certain norms or religious practices, etc. This was a subject matter of challenge earlier before the Supreme Court, as early as in 1973. The Supreme Court held that the right to the priest of this Bora community conferred by the statute is something that is protected under Article 26 of the Constitution, as it is the essential religious practice of a denomination. The same case and the same issue engaged the attention of the Supreme Court again, as late as in 2005, I'm sorry, I'm not remembering it correctly, 2005. The Supreme Court again examined the constitutional validity of Bombay Excommunication Act and found that the issue needs to be deliberated meticulously and in the light of Article 26 of the Constitution, taking into account the development of the constitutional law after the earlier judgment. Now, the very same issue of essential religious practice and what it is in season of the Constitution, another Constitution bench of the Supreme Court. So, there is a chance of this, or possibility of, what I would say that a possibility, likelihood of this matter being referred to a larger bench along with the Bora community case for an authoritative pronouncement on this issue. This is one aspect which or one ray of hope which we see on the judicial side. But still it is not going to resolve the issue once and for all. The issue would be pending there as a live adjudicatory issue before the Supreme Court. But what is feasible at this point is nothing but a legislation. But regarding the feasibility of a legislation, possibility of a legislation and its sustenance in the constitutional framework, etc., are also issues being deliberated across the legal intelligentsia. To what extent a law be made for nullifying the judgment of the Supreme Court, which declares a particular practice as unconstitutional for the reason that it is violative of the equality clause. That is an issue to be considered and pondered over with all seriousness. But still, legislation, though it cannot nullify a judgment, but it can destroy the foundation of the judgment. The reason for the judgment can be nullified by way of a legislation. Still, that legislation should pass the muster of the basic structure doctrine. Even if a legislation is going to be made by the state legislature, or for that matter the union legislature, the parliament, it must satisfy the basic concept or the cardinal concept of the basic structure theory that is propounded in the Keshavananda Bharati case on 23rd of April 1973. But one solution that is for the time being proposed is legislation by the state legislature or by the union legislature declaring the rights of the Ayyappa devotees, defining Ayyappa devotees, etc., can be undertaken by the legislature, and that legislation, if that is included in the 9th schedule of the Constitution by way of amendment of the Constitution, to a great extent the law can be immunized from constitutional adjudications and nullifications. What we see now is a private bill that is piloted by a member of the parliament. What is the scope of a private bill in this parliamentary democracy? We all know that we are following the Westminster system of parliamentary democracy. In a parliamentary democracy, what we see is legislation comes from the executive, that is from the cabinet. The cabinet or the ministry that takes up various issues, studies various issues, the department formulates policies, etc. The policies are made into legislation by the executive. A draft bill is being piloted usually by the executive. before the floor of the House. When the executive undertakes the exercise of legislation, it's very easy for it to get the nod of the Parliament. When a private member, what I mean by private member is a member who is not the part of executive, that is, who is not part of the Council of Ministers. Such a member can also pilot a bill in the Parliament or in the state legislature, which our parliamentary democracy permits. But it's very unusual for a private member's bill being passed in the Parliament or in the state legislature. The procedure that is prescribed for the introduction of a private member's bill is, he has to place it before the Speaker of the House or the Chairman of the Rajya Sabha, as the case may be. After getting approval from the Speaker or from the Chairman, the bill will be placed before the Parliament or the concerned House. It is for the concerned House to give approval for piloting of the bill. Usually, in almost all cases, the House is giving its nod for piloting the bill of a member of Parliament. But very rarely, Parliament is not approving or not giving permission for the private member to introduce his bill before the Parliament. Very recently, in 2014, Shashi Tharoor attempted to introduce a bill in the Parliament for decriminalization of homosexuality, which is objected to by one of the members of the BJP. The bill was put to vote and the House did not give its approval for piloting or discussion of the bill in the House. When we take the history of the private bills which were passed by the legislature or the Parliament, a survey shows that only 14 bills could get the approval or could get the approbation of the Parliament. The last one was in 1968. A private bill was passed by the Parliament, which was for extension of the appellate jurisdiction, criminal appellate jurisdiction of the Supreme Court. That was passed in 1968. Thereafter, we could not see any private bill being passed by the Parliament. But what is the important, even if it is not going to be passed by the Parliament, but sometimes these private bills are doing a great service to the nation, in as much as these private bills give a direction to the Council of Ministers to act on a particular issue. The private bills mooted by Bhupesh Gupta of CPI and Chittabasu of Forward Bloc in 1970 was in fact a catalyst for Mrs. Gandhi to bring in a constitution amendment for abolition of the Privy Purse. Though the bill piloted by them were not accepted by the government, but that was in fact a pointer for the Council of Ministers to act upon the demand of the nation. Then we could see another bill very recently that was passed. That is also, the proponent was Mr. Bhupesh Gupta. This bill, though, could not gain the support of the Parliament, but that was also instrumental in bringing the 61st Amendment, I think, 61st Amendment, which reduced the voting age from 21 to 18. So the private bills, though it is not going to be passed or not going to be accepted by the Parliament, it may give an impetus to the Council of Ministers to act. At least the Council of Ministers would be made, or they would be compelled to make clear their stand before the floor of the House regarding the issue that is contained in this Act. Then the present private bill that is mooted by Sri N.K. Premachandran contains two important provisions. One is regarding the declaration of status of the rites and customs prevailing in the Sabarimala temple. The provision that is sought to be introduced declares that the status regarding the customs and the rites prevailing in the Sabarimala temple as on September 2018 should be protected and conserved. This is one important provision which the bill contains. Then another provision is regarding the nullification of the judgment of the Supreme Court, which I think that it is not going to get the approval of the Supreme Court or any court of law when it is put to scrutiny by way of any petitions. That particular section would say that notwithstanding anything contained in judgment, decree, order, etc., the custom would be preserved. So that kind of a provision is something that is going to nullify or setting at naught a Supreme Court judgment, which cannot have its own legal legs to stand. Then another important provision which also is not appreciable for the reason that it cannot also get the approval or get the judicial approbation when it is put to scrutiny. It in fact takes away the power of judicial review enjoyed by all constitutional courts. The customs and rights prevailing in the Sabarimala shrine cannot be called in question in any court of law. This is what the provision sought to espouse, which also is not something a judicially appreciable stand, because it is something that is taking away a very important basic feature of the Constitution, that is regarding judicial review. So there are so many flaws in the proposed bill. If the proposed bill, if put for deliberation and its various clauses are discussed threadbare, and a new bill or new remolded bill emerges after curing all the defects and flaws in the proposed legislation, it may pass the test of constitutionality even if it is challenged. And it can be further immunized by way of a constitution amendment by putting this proposed legislation in the 9th schedule to the Constitution. If the legislation, if passed, is put in the 9th schedule of the Constitution by way of a constitution amendment, it is still subject to challenge, because in the decision of the Supreme Court after 23rd of April 1973 regarding the interpretation of the 9th schedule of the Constitution has come out in I.R. Coelho case. There is a history behind the introduction, or rather incorporation, of 9th schedule to the Constitution. When the Constitution was passed on the 29th of November 1949, there were only 8 schedules in the Constitution. The first amendment to the Constitution was necessitated for the purpose of incorporation of 9th schedule to the Constitution. The 9th schedule to the Constitution was necessitated because of the court judgments nullifying various Jamindari laws passed by the Bihar legislature and the UP legislature. The Jamindari system was abolished by way of various legislations. Those laws were challenged on the ground that it was violative of the right to property, which was then a fundamental right under Part 3 of the Constitution. The court nullified, the various constitutional courts nullified the Jamindari laws for the reason that it violated the right to property, which was a fundamental right then, guaranteed under Part 3 of the Constitution. But at the same time, the policy of the various governments under the government of state governments and of the union government was to bring in agrarian reforms. For bringing in agrarian reforms, the deprivation of right to property is an essential feature because the property was in the hands of a few. It was not going to the hands of the tillers. So anyway, the Constitution amendment was necessitated for the purpose of protecting the agrarian reform laws. So the first Constitution amendment was mooted by Pandit Nehru, which sought the introduction of Schedule 9 to the Constitution. The 9th schedule to the Constitution, along with the two other articles, were brought in by way of the first amendment to the Constitution. Article 31A and Article 31B of the Constitution came into being by way of the first amendment to the Constitution, along with the 9th schedule to the Constitution. Once a law is enlisted in the 9th schedule to the Constitution, it is immune from challenge on the ground of violation of fundamental rights. That is the device that was in fact molded by the legislature, the union legislature, for the purpose of protecting agrarian reforms. We all see that this 9th schedule was primarily incorporated for the purpose of protecting agrarian laws. But by practice, there was indiscriminate inclusion of various laws, not alone these agrarian reforms, were brought under the 9th schedule only to immunize the law from judicial scrutiny. This practice was being deprecated for quite a long time. Ultimately, the Supreme Court had occasion to consider the validity of 9th schedule and inclusion of a law in the 9th schedule in juxtaposition with the basic structure doctrine that was evolved in Keshavananda Bharati case. The Keshavananda Bharati case judgment was delivered on 23rd April 1973, which brought in a new coinage to the constitutional law of India, that is basic structure theory. The basic structure theory was evolved by the Supreme Court in Keshavananda Bharati case, and its application in fact was in a way curtailing the amending power of the legislature. It's a parliament. Though before that there was a notion that the parliament had unbridled power for amendment of the constitution, and which was to some extent curtailed by way of this new coinage, that is the basic structure theory. So the Supreme Court, when taking note of the indiscriminate inclusion of various laws under the 9th schedule for the purpose of immunizing legislation from judicial scrutiny, found it inevitable to have a revisit of the judicial pronouncements on the 9th schedule to the Constitution. Ultimately, the Supreme Court had undertaken this exercise in IR Coelho case. In IR Coelho case, the Supreme Court considered the impact of basic structure doctrine evolved in Keshavananda Bharati case. The Supreme Court went on to hold, after due deliberations, on the various constitutional provisions and the amending power of the Parliament, that those laws which are included in the 9th schedule to the Constitution after the pronouncement of Keshavananda Bharati case is subject to judicial review. The Parliament cannot immunize a legislation by way of a constitutional amendment for its inclusion in the 9th schedule. That power is curtailed by the basic structure doctrine. The basic structure doctrine says that if the amendment of the Constitution for including the law in the 9th schedule is tested on the touchstone of basic structure theory, if it is not convincing for the court that the basic structure has not been eroded, then the law is liable to be struck down for contravention of the principle of basic structure theory. The basic structure theory has been given more wider amplitude by the Supreme Court in IR Coelho case. But the Supreme Court has struck a word of caution by qualifying this basic structure theory and its application on the test of a law that is included in the 9th schedule. The Supreme Court said that unless the main or the essential rights are taken away, the law cannot be impeached on the ground of basic structure theory. The basic rights or the essential features which the Supreme Court noted was the rights guaranteed under Article 14, then Article 19 and Article 21 of the Constitution. When a law that is included in the 9th schedule is tested on this principle, the violation of these three fundamental articles would be demonstrated in such a way that the golden triangle, according to the Supreme Court, is breached. Only when these three fundamental articles are demonstrated as being violated by the law that is included in the 9th schedule of the Constitution, the law can be set aside on the ground of unconstitutionality. In the proposed legislation regarding Sabarimala, we could see that there are various provisions included which prima facie are against the basic structure theory that is propounded, like taking away of the judicial review, etc., etc. If some thoughts are bestowed upon by good legal brains in the Parliament, and if the Parliament or the Council of Ministers undertakes a comprehensive legislation regarding the Sabarimala issue, containing the rights of the Ayyappa devotees and also a precise definition of Ayyappa devotees, that law is something which in eventuality would become an unimpeachable law, and the constitutionality of the particular law is scarcely going to be challenged. The constitutional validity of the law, proposed law, is to be challenged once it is included in the 9th schedule of the Constitution. The petitioners will have to demonstrate before the court that there is violation of Article 14, then 19 and 21 of the Constitution, which is going to be an onerous task, and rather I would say that an impossible task for the petitioners who propose to challenge the law to be made by the Parliament. I think that we have traversed a lot on the religious rights protected by the Constitution and also the other cultural rights guaranteed under the Constitution in the wake of the private bill that is proposed to be placed before the Parliament by our private member N.K. Ramachandran. I think that it is time for us to conclude, because a lot has been said about the controversy regarding the women entry in Sabarimala. So we see in our Constitution, we are in an eager to protect the essential religious practices and also the cultural rights, which we have inherited from time immemorial. And it has been given a constitutional status in the Constitution in as much as it is included as cultural and religious rights in Part 3 of the Constitution of India. So we, in our country, that is in India, we have diverse culture, diverse religions, diverse traditions, diverse rituals, etc., etc. That is why the framers of the Constitution, while framing the Constitution, put in the preamble a declaration of the people of India to the following effect: we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. On this 26th day of November 1949, we, the people of India, do hereby adopt, enact and give to ourselves this Constitution. So this declaration of the people of India, while adopting, enacting and giving to themselves the Constitution, that we constitute India into a sovereign, socialist, secular, democratic republic, also for securing the liberty of faith and worship. I think that in the adjudication relating to the Sabarimala women entry, this primordial aspect of our Constitution, that is regarding the protection of religious rights, has been forgotten and has been given a go-by. Hope that the review petition may bring some results or solace to the devotee community as a whole. Thank you very much.